PELU Task Force hearing for April 10th, 2008. This is the Public Engagement Land Use Planning Task Force, and we are here to discuss the potential recommendations under consideration by the task force for addressing public engagement land use planning. I'm going to go ahead and set up the basic rules for the forum. You have to sign up to speak. You can still sign up. Every person will be granted 3 minutes, and if you're representing a group, you'll be given 5 minutes. The timer will be in effect. The forum will end at, how many minutes are now? Wasn't it 10? Yeah, if it should go as long as 10, we'll probably try to call it around then. And if you have any written testimony you submit, please give it to Theo Wimberly. I'd also like to announce that the PELU Task Force does have a website. It is available at www.co.hO.md.us/countycouncil/cc_PELU.htm. But I'd recommend just going to the county website, clicking on County Council, and clicking on PELU from there. Comments may be submitted through the website. Also, PELU has maintained a blog since the task force started. It is available at howardcountypelu.blogspot.com, and it is currently accepting open comments, and it should be accepting open comments through the 15th, correct?
Yes. 10 days from today's date.
10 days from today, so that'd be the 20th. I'd like to read the disclaimer here on the proposed potential recommendations. Says the following is a list of potential recommendations under consideration by the PELU Task Force. Final recommendations will not be made until after the public hearing on April 10th, 2008, when the task force has had a chance and deliberate and consider each recommendation. We have meetings scheduled for April 15th, where we'll be voting on individual recommendations. April 22nd, April 30th, and
we actually have a question about the week of the 22nd.
There's a council hearing on the 22nd, so I think that the 23rd
is the 23rd? Okay, apparently the meeting's on the 23rd. There's a meeting on the 30th, and the final report is due to the county council on May 5th. So with that in mind, I'd like to go ahead and call up the first. Okay, we're going to have everybody on the task force introduce themselves. Let's start.
Susan Shine, Highland. Bridget O'Donnell for the Howard County Citizens Association.
Tim Sisinski from Columbia.
Debbie X, Columbia.
I'm James Howard. I'm the resident co-chair, and I live in Long Beach.
My name is Bill Erskine, and I live in Clarksville.
I'm Kathy Hudson. I live in Oak Ridge.
Frank O. I live in Columbia.
Bill Lewis, I live in Oakland Mills.
Andy Sachs, I live in Columbia.
Judy Fisher George, I live in North Laurel.
I'm going to go ahead and ask the first person to come up on the list. I believe it says Jim Adams.
If you don't mind me mentioning, there's a column in front of my name. Excuse me, I was kind of cold. And it says, if you don't want to testify, then don't work there.
Would you like to go ahead and speak anyway?
You drafted me. I really didn't want to testify tonight. I want to stay in the middle, but I think I'm going to tell my story anyway. And I'm going to stick to it. A couple years ago, I ran for office. The platform was going to, county council. Platform was going to be education. Within a week of following, I had telephone calls and individuals approached me about zoning problems, land use problems. I didn't know what they were talking about. I had had 2 incidents in my life, only 2. I must have been lucky. But so many people were encountering problems. The rest of my short-lived campaign was involved with this stuff. I watched this problem grow. I watched the citizens, and it's been a few weeks ago, and I think you'll probably hear from some of them tonight, who gathered, and these were private citizens, gathered at Miller's Library, and over 60 people showed up. I think this is telling the county something, and I think it's bad news. I think it has to be addressed. I think it has to be addressed now, because in 2 years there's going to be another election, and the people that are in office now are going to have to show us that they have substance and can address important problems. The kind of problems you're looking at, and probably have learned a lot about, are the kind, I think, that affect people in a very personal way. It's not something that's abstract. But I'd like to make a recommendation, and then just, maybe it's called a silly comment after that, but the recommendation is, even though it may not be in your power, I think you should put it in writing, that this group's lifespan should be expanded beyond the date, what was it, May 5th or something. I really think you should. I think there should be a follow-up group of people who are informed, aware. There should be no retraining. I think you're probably the most qualified group of grassroots that we can find. So that lifespan should be expanded, and I would say at least 1 year. And there should be some measure of what's accomplished with the items that you found. The other thing, you may not take me serious, or you may not want to put yourself in this position, but I think someone ought to ask, where are the developers? What happened to those folks who said they were going to be on this task force, and they call themselves developers? Okay, we've got good developers in this county, but I want to know where they are in the task force and why they're not here. That's it. Thank you. Any questions?
Yes, actually, we have two very talented developers, attorneys, who are active. Bill Erskine, our co-chair, represents the development community, and saying, oh, there's a Talcott firm is there, and he's been very active as well. And we've had, I believe, the Economic Authority representative participate in some of our meetings, and at least one other developer person. So I think it's a fair representation.
My time's up. Anyone else?
Jim, I'll just make a comment that
Yes, sir.
I was at the Miller Library, and there were
You were.
there were
I
70
was
people.
proud of you. You took a lot of flack. You're a man's man.
I swore I'd never wear my tie again.
Yeah. I was going to defend you, even though I was on their side.
Some folks thought I looked like Greg Ham, so
You're a good
I
man.
appreciate that.
Thank you, Jim. Next, I have on the list Mark McPherson.
Hi, I'm Mark McPherson, a 40-year resident of Howard County. I live at 48264 Lane, Park 2. I feel that undue pressure since 1991 as a resident by commercial real estate enterprise within my residentially zoned Eastern Howard County community. It seems like growth for its own sake is been touted.
Could you speak a little louder?
Okay, I'm sorry. Growth for its own sake to me seems a tumor. And growth just, it seems almost unchecked. I attended a meeting that was just referenced to at the Miller Library, and they had a number of points that came up. I'd like to read those. One is remedy to allow citizens standing in legal matters. Halt using problematic development building methods until permanently solved, such as the group septic plans frozen immediately. Abolish the planning board. Separate zoning board from county council. Developers follow the same laws as other businesses, concerning signage particularly. Persistent rezoning under citizen opposition curtailed. Overhaul comprehensive rezoning process. Stop changes to zoning regulations that modified county-wide zoning. Stop economic eminent domain. Any change in zoning to be transparent, visible to residents. Low-income density transfer not allowed. Zoning changes subject to referendum. Enforce the Charter Section 202G. Any county representative with zoning power takes zero developer building funds applicable for campaigns and any other money or land or asset taxation or transaction. Developer attorneys not allowed to represent other county agencies. Eliminate conflicts of interest. Revise current methods to include a mix of affordable housing with other types of housing. Enforce developer not polluting waterways and charge for immediate cleanup of any pollution. Stop changes to environmental conservation location. Fix problem with conservation wherein trees are planted and die. Howard Community College implement a covenant. County to comply with their own regulations as a one-third owner of the entire county. Enforce existing laws, regulations regarding development and North Laurel situations specifically. adequate infrastructure in place were fully funded prior to development initiation. A new county position for paid resident representative on land use matters. County to enforce regulations against developer with equal vigor as that against citizens. Our group insists for full participation in the 210 general plan. Over 55 housing no longer requires credits. Remove county incentives. Abolish the councilmanic districts. Revise current planning board members and functions to redirect towards citizens by district and add at large member. Rotate director of the planning and zoning position. ZR 95 withdrawn in current form, which includes ability to transfer adequate infrastructure and transfer of sensible development constraints to other areas. Basically, it's just, and my point, personal point is, I think that residents should be burdened by this process of growth. You have to pay for people's fees, and that's a new thing. That's right. Thank you.
Are you able to send us a copy of your remarks? Is that something you can email to us, or do you have a copy you can leave with
I
us?
do have a copy. I can try to make a copy of. Let's see, do you have an email address? I'll send it to you.
You can use the website.
Yeah. Or you can give your written statement to Theo.
Okay, yeah. You can make a copy.
Yeah. Thank you very much.
Thank you.
Next, I have Ralph Ballman.
So you're going to go anywhere.
Get it for everybody?
Go ahead.
My name is Ralph Ballman. I live at 9927 Rose Trail in Ellicott City. Like everybody, a lot of other people, I have a long list of things I'd like to complain about, but I narrowed it down to 3 because I think they're kind of doable, and I should be able to, the council, I think, could do most of these without too much controversy. The first one I want to speak about is what we call the road acceptance or development dedication hearing, Public Works Board. I consider this as important a meeting as any of the other land use meetings. Whereas at this hearing, that the neighboring residents and the new residents of the community have a chance to comment on the final product. Unfortunately, most people are totally unaware of this part of the land use process. Often one hears people complain that many aspects of development that were supposed to be done were not done correctly. This meeting is where those concerns should be addressed. Since this hearing determines when the county will release the bond money to the developer, it is at this point that the county and the citizens have the most leverage to get things done right. An example of the importance of these hearings is my own cul-de-sac community of 11 homes by Bethany Water Tower. In 2001, I found out about our dedication hearing 2 days beforehand. I told my neighbors, and 4 of us went down to the hearing. We sat there and listened to the developer's representative and then the Department of Public Works representatives state that the development had been completed as signed and that road and infrastructure should be accepted by the county and the open space lots should be turned over to the homeowners association. Everything was fine and dandy. Then we got up and presented our list of complaints and concerns along with some photographs to support our statements. And after some lively debate, civility wasn't a factor in those days. The board voted to postpone the dedication for 2 months and asked the Department of Public Works representative to meet on site with the developer and residents. He did this and arranged for everyone to meet the very next morning. The next morning, he looked at the things we had complained about and decided a couple of them were okay, but some were not okay. He ordered the developer to fix 10 feet of busted curbing, to patch an 11-foot square sunken section of the shared driveway where water was puddling, to regrade the slope on 100 feet of the sound barrier, and to re-dredge, regrade, and reseed the stormwater management pond. The developer had to bring in a dragline boulders and spent 2 weeks fixing the pond. All this for a development that the night before was fine and dandy. It should be noted that these things, if not done by the developer, would have had to have been done by either the county or the residents. My suggestion is to have the county council pass a bill to require the developer to post the property with notice of the dedication hearing 30 days in advance of the hearing, and send written notification of the date and time of the hearing to the same persons who were notified at the pre-submission meeting, along with all persons who now live or have purchased property in the development. And it may even be helpful to have the developers hold freedom dedication meetings. I think a change like this could benefit the residents, the county, and even the developers. It's just I think it would be better. And I'd urge you to even read it for yourself. One, the other one is homeowners associations, governments in open states, and the other one deals with the training and education of members of various county land use boards.
Thank you very much.
Thank you.
Thank you for your good ideas, too, suggestions.
Next is Grace Kubancic.
Good evening, members of the task force, and both Chairman Espine and Chairman Howard. I'm Grace Kubancic. I'm co-president of the League of Women Voters, and I'm testifying tonight on behalf of the League of Women Voters. Up front in our testimony, you'll see that we extend a major thank you, one, for the experience and energy that you bring to the issue of public engagement. All of you have been involved and represent years of experience, a lot more than this gray hair on my head. We also appreciate the fact that you have allowed the public, when they have attended your meetings, to participate openly with you and make comments, and the fact that you have attempted to at least use the website for interaction between committee members so that the public can actually read that interaction, and we do appreciate that. I will make a note in trying to prepare this testimony and share it with our board to get approval. We found it very difficult to get the subcommittee report recommendations off. Many times the site was down, so if there are people who might be here tonight not making particular comments on those, it might be because they had some difficulty. So we appreciate you giving the handout tonight, and some of us might be giving you some additional written comment based on some of those recommendations. We have three major concepts to really encourage you to do. One is simplicity of process. Okay, it is too long, too involved, too detailed. Two, uniformity of process. That is everything from notice to the amount of time to how hearings are conducted. And three, probably the most important, the continuing opportunities for public engagement. There was no comment on standing in our testimony. However, it is an issue, okay, that this committee should be making some recommendations to the county council on. We give you a list of specific recommendations, and I'm not going to go through all of them. I'll highlight, okay, we do talk about notice. We do talk about technical staff reports. A number of your subcommittees have also given you recommendations in those areas. We also talk about posting of property and property owners' notification. We feel very strongly the League, after the comprehensive zoning process the last time, wrote a letter to the council and urged that the county council, since that action was the first legislative action that they took in a comprehensive, to use that moment in time to record their impressions of that and make suggested changes. We felt that there were a need for a number of suggested changes. They held one meeting on that. There was some recordation of that meeting. This committee ought to get a copy of those recommendations, and we remind the current council of some of what the past council suggested. We also think that the county council rules for approval of land use master plans and comprehensive zoning, their own rules need to be extended. It's a legislative act. There are requirements around a legislative act as to how many days we think at a minimum for master plans and comprehensive zonings. It should be 120 days for adoption, and that there always should be adequate time for public consideration of any county council amendments prior to a vote by the council. We also talked about information about proposed zoning regulations and map changes. We feel that the Department of Planning and Zoning is clearly aware these are coming up, and even before the technical staff gets the report up on the website, which is good that they do that, and they do that very faithfully. There ought to be adequate notice as soon as possible, at a minimum 30 days ahead of time, at least identifying what the issue is or what the property map proposed change is. Public rights to be heard should be protected and encouraged. Rules of procedure for all of the public entities need to be scrutinized and try to make as uniform as possible. Opportunities for public comment should be extended. The Planning Board, in its recent adoption of its rules of the procedure, extended public comment to the end of the petitioner's case, literally the first presentation of that case. It used to just be if you showed up on the first night, you had to sign your name in. If you showed up on the second night, you missed the vote. If the petitioner is still proposing, okay, whatever they are proposing, the public can still sign up. That's an extremely important extension, and it should be extended for all other bodies. Public's right to know is an extremely important concept, and I think all of your subcommittees are clearly zeroing in on that. The League has a slightly different opinion than the administration about a couple of things, but that's okay. We're going to keep pushing this idea. The Department of Planning and Zoning, the Ombudsman, all right, I'll finish that too.
I'm interested in hearing this.
Okay.
Take your time.
The Ombudsman, okay, and the Zoning Council have to be partners with the community. And by partners, we mean, okay, they should be available, for free community meetings. We saw a number of recommendations that a number of your subcommittees are making, okay, and some are suggesting an actual requirement that they be present. We think that their visibility in the community at those community meetings is absolutely key and essential. Citizens rely upon the expertise of the Planning and Zoning Department, and I'll do the reverse. It's an opportunity for the Planning and Zoning Department to learn the community better. All right? The Ombudsman, I am pleased to see, okay, is at many community meetings that have nothing to do with planning. I congratulate her on that. All right? I think the more she is out and visible, and the more community meetings that she can be present at, the better. All right? And finally, the Zoning Council has in its requirement that any community association can ask, okay, for that expertise to come. They don't give legal advice to those of you who are attorneys. You don't have to worry about that, okay, but at least they can tell citizens about the process, all right?
And that's existing law.
That's existing law, okay, not well utilized, okay, and probably because not well known.
Right.
Okay, all right. The other thing we talked about is zoning regulation amendments. The League will be supporting Council Bill 26, which restricts the time frames for individual petitions. We're going to suggest a couple amendments to that, but we're putting out to you something. One, okay, is that in the year of a comprehensive zoning petition, 3 months before that petition, there should be no zoning regulation CRA amendments proposed. There ought to be a moratorium on them. And for the year after, there should be none, unless a technical error occurs. And by that, we need individual petitions. The legislation still allows the Department of Planning and Zoning to create those zoning regulations and also a council member. So there is that window of opportunity if there have been technical errors. We thank you again very much. Ada Before-Fish, who's been a member of this committee and as the League representative, is celebrating the 50th anniversary of her parents this weekend and had duties to pick up people from the airport tonight, so she apologizes for not being here. So again, we thank you for the work that you've been doing.
Thank you very much.
Thank you. Next is Salvatore Constantino.
Good evening.
Good evening.
My name is Salvatore Cosentino. I've been a 30-year resident of Columbia in Howard County. And I attended a meeting at Miller Library and got acquainted with Howard County issues and published thereof. And in contributing my little piece in the way of advertising to that, and in the ad, if you pick up a copy of the library, Howard County issues.
Excuse me, we're not picking you up on the microphone.
Sorry.
If you could
I'm
move
just
forward.
moving closer. I was complaining, not hearing the other side.
Yeah.
Generally, I'm a loudmouth, I try to hold it down. But to make a long story shorter, in Howard County issues, I quote Galileo. And because my background is primarily science, although I work as an engineer and write specifications, for legal documents, so I analyze this document. But the point I really want to make is, let's find out what we're really talking about. Are we talking about planning, or are we talking about property rights? Now, all I see in here is an issue over property rights. And the issue over property rights goes back to the Nile Valley and the Indus Valley and the valleys that flood on a regular basis, and then the lines of property have to be reestablished seasonally so farmers know where to plow. Well, this is an age-old problem, folks, and we shouldn't be hitting the reset button. We should learn a little something about history and how civilizations from China to Europe have been solving property issues for years and years and years, and how to build in certain territories. And I'm very familiar with observing Italy, where they build on the hillsides and they leave the valleys to be used for cultivation. Now, that's a pretty, not only does it make sense in the European experience, because it's harder to fight uphill than it is down, and Europe was known for its wars. So, and likewise, they had good sense not to build in a flood zone. I mean, it's really, give the people credit. We're not really learning from experience. We're not defining things correctly. The lady from League of Women Voters is focusing on procedural issues, and that's good. But we have to focus on philosophical issues as well. And who has the right to determine property? It's individuals, not, and the federal government through the Supreme Court has made corporations persons. I personally don't recognize corporations as persons. So I think people, living, cogent people, corporal people, or corporal people, not corporate people, have the right to determine how we live and how we associate with one another and how we plan our community. So I've gone to school ever since I attended that charade that was called a charrette. I've gone to school on planning issues and so forth. And I think we should get to planning, discussing planning, not legal and procedural issues, but planning and how we want our community and our county to be planned. Thank you.
Thank you. Before we have our next speaker, I'd just like everyone to know that we've been joined, I see you in the back of the room here, Mary Kay Sickety and Jen Treisler, two of our council persons, have joined us this evening. Mary Kay and Jen were the sponsors and co-sponsors of the legislation that brings us here today. They introduced the county resolution that created this task force. So I appreciate you both being here and they're listening. So be aware.
Next is Bill Taylor.
I'm Bill Taylor, represent really myself, but maybe speaking for a group of about 150 homes in the Greenberry Lane, Route 32 area, which there's a proposed 50 condo units on 50 acres in an RR zone. We've been through the planning and zoning. At first, they denied the appeal by the developer there. And this was, they deemed it not in accord with Howard County General Plan, which is explicitly stated that it's not, this is not the type of a development that should be in this area out of the PSA. The developer took it to the Board of Appeals, and they Eventually, in our view, we testified in many cases, many sessions with the Board of Appeals. And the Board of Appeals, we feel, just rubber stamped it. They really ignored all of our objections to it. All of our interests seem to be discounted. I think what we're wondering now is what can we do now? We've been through the circuit court at our own expense. We've raised our own money and hired our own attorneys to take us through the circuit court. 1 week or after the circuit court judge heard it, he retired and he rubber stamped it again. We're now in the Court of Special Appeals. You can go to nocondos.org and hear our case and see the testimonies that we gave. There's been really no addressing of these issues. This would be a community that would have a community septic proposed, just like the Cattail Creek one. It would also have a community well system, so that the adjoining neighbors are very concerned about water and as well as the sewer problem that may entail. So I guess we're really wondering what we can do. I know that we can't address all of that here, but where do we go from here? Should this thing be allowed, and how can we get the ear of, it seems it's interesting to me that once Board of Appeals gets it, Planning and Zoning has no more hands on it anymore. Any questions for me?
Were you speaking for a particular group, like have you organized your...
We're fairly well organized. I don't know if there are other members here tonight, but we're fairly organized. I was at the library where you were the other day on the hearing. It's wonderful to me to see the PELU having formed. I wish it were here a couple of years ago. We might have been heard a little bit better than we're hearing now.
One thing I will say is that there is, recently there's been legislation introduced that would affect, if this is an age-restricted condominium, is it? I believe that would fall under new legislation that has been proposed that would require to go through a design advisory panel. So you might take a look at the county website and see how that legislation might affect your project. It may not prevent the project from occurring, but it could influence how it ultimately looks. It's a design and construction.
All right. Thank you.
Yeah, I just wanted to also mention, too, that I think one of the elements that this committee has become very aware of is the kind of lack of the citizenry to understand the process and to get out in front of these issues and do something about them. And a lot of our recommendations revolve around the idea of setting up simple, understandable means of allowing the citizens to participate. So hopefully groups like yours can meet with the developers in advance of these projects and affect some form of change that makes it more meaningful.
Well, there's another 70 adjoining acres that they say they have no plans for. Well, as soon as this one goes in, I'm sure that other 70 is going to be recommended. Thank you.
Thank you.
Thank you very much. Next, I have Diane Butler.
Good evening. I'm Diane Butler. I'm the Vice President of St. John's Community Association, obviously for the association as well as myself. I want to thank the board. I think that we're doing a lot of work here, and I think there's a lot of work left to be done. Our association has been dealing with infills, stormwater management, pre-submission meetings, and most of you have heard me speak at different venues a lot of different times. I had an issue come up today, though, or the last few days, that have kind of stunned me and have kind of changed what I want to talk about today, because this whole process is for improving public engagement. And all the other things I've talked about still apply, et cetera, but today I want to talk about lack of progress and changing of plans without public input. I spent 5 years working with the county on the new Middle Library project. And we had focus groups, and people were invited, and we brought it all up, and they set up a PLR, and all the things that we needed. The Middle Library is extremely too small to afford the size it needs to be. It's been dripping water on my daughter's head for years and years and years. And the community worked with the library system and with the county to come up with a plan. This library's way, way past overdue being put in, and as a matter of fact, it was already, then it was funded and set up, it was supposed to be 2005, we're now 2008, now we're talking 2009, 2010, whatever. However, the public was involved in this process, and the public told them what they needed and what the community needed, and the master plan for the library was set up, and the community agreed and said they were happy with it. And I find out from a letter to the editor in the newspaper that 22,000 square feet had been removed from the library, and I immediately called Valerie to find out what happened, why there was no public process, why nobody knew anything about it, and I got some things back from her about changed circumstances, that something to do with the charrette for Columbia has changed the Ellicott City Library plan. When we have a master plan, and the plans that we set up, we need to stick by our plans. And to take and change our plans, this isn't the first time. I mean, there's just a lot of different things that happen when we work for years and years and years on projects. The people, the citizens work for years on projects, and then we get either a new county council person or we get a new county executive, and all of a sudden, too bad, they're all gone. The plans are totally gone, and there's no input, there's no help for it, and it just has to stop. If people are so angry and so upset about things like this that happen behind their backs, and by the time they find out about it, there isn't anything that can be done. And this has happened, it's just like our road's supposed to be repaved. So we were supposed to get traffic calming. For 12 years, the association worked on this traffic calming, and everything was put off because waiting for the road paving. Well, they didn't repave the road. They're never going to repave the road. We have a new county executive. He isn't going to do the traffic calming because he doesn't like it. So he has some new idea. Well, there's 12 years of work down the drain, and there's no discussion on it. And the discussion that I tried to bring at one of the meetings was totally dumped on. And now I have an association saying, well, now what are we going to do? And so we have all the work that goes into these things. You need to respect the citizens here, because the citizens are who pay your taxes and pay. The council and the county executive work for us. We don't work for them. And it's so frustrating, because I've been president of the association for years, and every time, we work on things, not just traffic calming, we worked on, I've got water issues that are still. The guy who came out to look at the water issue says, wasn't I out here a year and a half ago surveying the same stuff? And I said, yes, you were. Because why hasn't this been done? I don't know, but we're still not getting things done. There's just lack of progress, and there's lack of public input still that we're just forgetting about. And we can go through all the zoning and whatever. We know the issues that are there. We just, we've had that over and over again. We've worked on the infill over and over and over again. But we're changing processes and we're changing master plans without any public input. I'm so offended and so upset after all the public stuff that we did on this, that this was snuck behind us in a political move. I still haven't even been able to formulate how I want to go about dealing with this one. But I don't see where General Growth Properties has anything to do with the Ellicott City Library and the plans for our community and the center that we needed for our community. It's like Elkridge is always sitting out there with lack of schools and lack of whatever, and for some reason we're just not getting enough say, and you need to understand that there are community programs that we need implemented, and we need public input, and that's what this committee is about. And I don't think we're seeing all of that brought together. I'm sitting here with the budget from last time where it says $35 million for the library, etc., and I have the new budget, from the 2009 off of the 2008 budget. It's just totally been changed, and nobody bothered to alert the public so they could even go to the budget hearing and discuss it.
Thank you very much.
You're welcome. Thank you.
Betsy Singer, please.
Good evening. I'm Betsy Singer. I'm representing the Howard County Citizens Association. I'm its vice president. Can people hear me?
Yes.
I always need a booster seat. in any event, Howard County Citizens Association feels very strongly about this whole entire process. This is very important to the citizens of the county. Public engagement in land use really goes to the heart of what we're all about as a citizens activist organization. And we do want to start by thanking Mary Kay Siggety and Jen Teresa for establishing the task force in the first place, realizing how important the process of managing our land resources is to the county. We believe very strongly that the process should be transparent for all parties involved, especially affected members of the community. Public trust in county representatives and staff and developers is essential to any system that claims to represent the public interest. Unless the system is clear and understandable, it will not be workable or accepted by stakeholders, and thus will function poorly to the frustration of all involved. And I think we've heard some frustration tonight, and I think all of us share in that. And after a review of the draft recommendations from the task force that were produced relatively a short time ago, we do wish to highlight some of the recommendations and reinforce our support for the following areas. We strongly support creating a handbook for citizens, land use, and how they can participate in the process. The handbook should be written in plain language and outline the steps involved from beginning to end. There's a great deal of confusion about the whole process. You seem to have a lawyer to get through it. And it should clearly describe how to file a complaint or an appeal and include sample scenarios and make clear that complaints should be lodged before DPC releases a developer's bond. HCCA also supports having a site on the website where people can go and enter the number. I know I've been out in the neighborhood and seen a sign posted, something's going to happen here, and there's a number on it, Riverdale, for example, or Town Center, for another example. And if one could go to the website, put in the number, and have information come up about what is the development, what is the proposed development, what's the name of the developer, contact information for the developer, and also the name of the county employee who's in contact for more information would be extremely useful. Technical staff reports that are made by the county should be available on the website in sufficient time before a hearing or a meeting that requires a technical staff report, like maybe 2 weeks, to give people a chance to review. We always seem like we're running to play catch-up and don't have time. And during the comprehensive rezoning process, the public comments to the planning board should be made at a public hearing or via email to a web page open for public review. All properties being considered for rezoning should be posted. The county should send written notice to property owners and adjacent property owners, not just adjoining owners, of a property that's being proposed for rezoning, including an explanation of how to engage in the process before the planning board and the county council. The county council should set a cutoff date by which all amendments to the comprehensive rezoning ordinance must be made before there's a final vote. And the period should be, between the cutoff dates and the final vote should be sufficient, say 30 days, to allow for public comment. Pre-submission community meetings should be convened by the developer for all development proposals, including commercial, retail, and government projects in all zoning districts. Under the planning board, we should discourage rezoning via ZRAs for individual parcels or text amendments. Rezoning should be in the comprehensive zoning process whenever possible. For county hearings, the technical staff report should have a plain English summary at the beginning that explains the reasons and the effects of the proposal and lists the relevant staff, people who can be contacted for more information and for response to questions from the council. We feel that a people's council should be a party that represents the public interest in any type of land use issue in any forum. And I understand that this is a situation that currently exists in Baltimore, Hartford, and Montgomery counties. And finally, technical staff should be available at planning board hearings for responding to questions and concerns, examination and cross-examination, if you will, concerning any technical staff report. So that concludes the highlights of the comment from the Howard County Citizens Association.
Thank you very much. Any questions? Thank you very much.
Next is Stuart Cohn, and following that is Stephanie Porta.
Good evening. My name is Stuart Cohn, and I was honored to have been a member of the County Executive Planning and Zoning Housing Transition Task Force. In January 2007, our group made recommendations to the administration that were visions to be considered for enactment. I'm glad to see that our transition team and the Public Land Use Engagement Task Force are in many instances compatible. There is a Japanese proverb that states, "Vision without action is daydream. Action without vision is a nightmare." Both groups have clearly articulated the vision. Now we need action to improve our, quote, "lousy zoning process," unquote. This is not just being said by concerned activists of the county. It was also stated by Guy Gazzoni and seconded by Ken Ullman and Chris Burton, Democrat Republican. It was also at the last of the 34 Maple Lawn zoning hearings in 2005-2006. During the years, I've become a pessimist. Hopefully, this task force will take the necessary action to prevent nightmares by recommending to the County Council solutions so they can approve measures to fix the broken parts and bring optimism to the table. I have the following suggestions that could brighten the public concept and improve the zoning process. Change the Howard County website and create a separate task force category on the left side, vice the county's task force embedded in the County Council tab. This in itself would assist in your potential recommendation in providing, quote, "a web page on the county website devoted to Wade's links to how a citizen can get information from the government," unquote. And I'm happy to report that I've been working with Ms. Flowers on this very issue, and hopefully it will get resolved. I believe it's very important. If it wasn't for Mr. Randy Stack, I probably would never have known that this was embedded in the Cumberland County Council. And there's been other people that have told me that. So, as I said, I've been working with her, and I appreciate it very much. She's been excellent. The role of both the Planning and Zoning Board's Rules of Procedure booklets that I haven't been updated since 2002. I refer to these books right here. Requires whether they are rules or nothing more than guidelines, as some county officials have stated. The County Council and the Planning Board need to make the determination and follow the rules if they are indeed rules, or change the title of these booklets to guidelines. If they are rules, then what are the penalties if they are not adhered to? The outcome of the definition of these booklets are critical for not only PELU's potential recommendations, but would contribute to informational and knowledge sharing for the public awareness. They should be used for developing a partnership to teach land use processes, and as a means of as you recommended, to create a handbook for citizens on land use and how they can participate in the process. May I go further? Thanks. I'm sorry. Without a clear definition of what these booklets represent, we will always have a lack of trust in the zoning process. The question that remains is, why haven't these booklets been updated in 6 years? There have been zoning bills passed to reform the process. These are thanks to county executive and delegates for zoning involved who sponsored zoning bills to aid in the process, yet they have not been incorporated in the documents. Why haven't they? One of these bills in particular, Bill number 58-2006, that was adopted by the County Council, was to require petitioners to submit all technical reports 2 weeks prior to the public meeting, as well as a period of time posting of signs for advertising, planning, and zoning hearings. The public has the right to be informed of these provisions. They're not in this book. A third item that I'd like to see incorporated is follow the general plan, particularly section 4.22, is not adhered to, which states, develop a comprehensive health and human services plan. Over the years, I have attended zoning cases, and the issue of the healthcare infrastructure is not discussed. It needs to be, especially with BRAC, and I'm proud to say I'm a member of that, in the Health and Human Services, coming in, and as long as we have 1,850 units per year, and the lack of health care of personnel, doctors, and technicians. I recommend that any zoning case that calls for an increase in Howard County population shall have a designated official from the Howard County Hospital testify whether the hospital can more than satisfactorily handle the influx of new residents, whether it's emergency or long-term care. This is especially important, I'm almost finished. This is especially important since Maryland is rated 45th in the United States concerning the average length of stay in an emergency room, which is 4 hours and 37 minutes. Yes, it's time that we all get our act together and zone in the process so we can plan accordingly with the goal of informing and educating the public to provide a level playing field for all. And I appreciate it and thank you for allowing me the time, sir.
Thank you very much.
Thank you. Could we get a copy of your testimony? Okay, great, thank you. Next is Stephanie Porta, and following that, Susan Gray.
Hi, Stephanie Porta, 10382 Baltimore National Pike in Ellicott City. Not very organized, I kind of some scribble scratch here. My husband and I have been following since comp light and comprehensive rezoning, and I'm here to talk about DRA. I really think, I know Courtney's doing a good job trying to just allow them twice a year, but they really need to be gone. I mean, this is about public engagement, citizen awareness, and the DRA really does not give that to neighboring, somebody that can be affected by a DRA. I mean, this is the notice. That's the only legal notice that the DRA has to give in the back of the paper, twice, two successive weeks. And if the DRA is passed, it changes the zoning for all the zones of that particular zone in the county. So like us, if that would have been passed, or part of it was, it changes the property near us that we were concerned about, but it also changes the property 10 miles down the road that were zoned the same, 20 miles the other way that were zoned the same. These people knew nothing of this. We personally went out and told them about it, and they knew nothing about the DRA. So I really think, there are other ways, like Grace was saying with the DRA, there's technical errors that, if something really needs to be changed, the DPZ can put something in for a DRA. But I think they're not fair to the citizens. People they are not notified properly of, this potential change in zoning. That's all. Thank you.
Thank you very much.
Thank you. Next is Susan Gray, and then Angie Beltran.
Hello. Good evening, board members. My name is Susan Gray. I've lived in Highland, Maryland for 25 years since Bill Erskine's mother sold me my house.
They cut your grass on it.
Bill cut my grass. Don't say that. That makes me too old. Anyway. I am a land use attorney. I have been a land use attorney now for 17 years, something like that. I initially practiced in Howard and worked only for citizens. And I became incredibly discouraged and frustrated. I'm not sure I won any case in Howard County. And after the Department of Planning and Zoning tried to charge my clients $24,000 to run off 2 copies of a transcript that already had been prepared, I got even more frustrated. And then with the community septic system at the Villa of Cattail, the project I was fighting, never became operational. From when we knew from day one it would never be operational, I left the county and refused to practice law here. For about the last 7 years, I've been practicing law in Montgomery and Prince George's County. And I've had a blast. I've had more fun. It's been so exciting. I've been able to work with wonderful people, a wonderful government. I've worked with a lot of good developers, and I know the process can work. But it's not going to work sitting around a table and coming up with, we think the sign should be this, we think the sign should be that. That's laudable, but this county has very fundamental problems. Number one, it does not obey its laws. We have a charter provision, 202G, which allows zoning decisions to be taken to referendum. It has never been enforced since day one. Comprehensive zoning we can take to referendum, that's great. But everything but change and mistake cases are required under that statute to be referable. The county attorney's office knows that. In fact, in 1995, when the Charter Amendment Committee met, they tried to get that committee to change the language of the charter or to recommend that because the zoning regulations were not consistent with the charter. Hey folks, the charter is our constitution. The regulations must be consistent with that. That is a basic thing that has to happen. Our regs have to be changed so that we, as citizens, if we want to get our 5,000 signatures, can vote on these rezoning. Right of appeal. A fundamental reason my clients have been very successful in Prince George's County, and they sit around the tables with the developers, with the planning staff, and they've got a place at the table because they have power. They have a right of appeal that is much broader than ours. We have some rights of appeal, but a resident of PG can appeal, a taxpayer of PG can appeal, and a homeowners or a civic association affecting residents or property owners affected by a project or a proposal can appeal. They've got a starting point. We have some of those rights, but they can go in at any point in the process and do those appeals. Prince George's has very good zoning regulations. I went back through in our zoning regulations, even notwithstanding that we're not complying with the right of referendum, we have one floating zone after another, and they have essentially no standards. I can keep going on for a few more minutes, but that's my time.
If you have other points that you want to hit quickly.
Okay. We need to put tight standards in there so that people have protections. And you can't do these text amendments for individual properties. They are absolutely illegal. Sang should know this, and Bill, remember the old case, Mayor and County Council of Rockville versus Rylands? The judge who did this is former developer attorney. It's a masterful decision. It's right on the money. You just can't do it. So my suggestion, number one, is get rid of the proposed legislation that you package these text amendments proposed by individuals. Prince George's, I don't have to deal with text amendments that are proposed by individuals because the county will not allow them because they're illegal. Just get rid of that, require everything to come through your council and to come through DPZ. It won't solve the problem because some council members will propose changes for developers, but those are few and far between. And then you have somewhat a way of keeping your council people accountable. So no text amendments, no poor PUDs. Make your regulations, make your zoning requirements very, very clear. No more rezoning by DPZ, such as with the tower, where they didn't have the density allowed, and yet that plan was approved anyway. No more rezoning by the planning board by changing the final development criteria on something. And I guess I'm probably the only one in this room, but I have seen the planning board work really well. I have heard at meetings in the last couple of weeks of folks in this county being very frustrated because they've not been able to incorporate general plan principles into the review of their subdivisions. If you have a planning board that under the subdivision regulations is given the ability to do that, they can work hand in hand with the community and with the developer to make sure projects are compatible. When I go in with clients in Prince George's County, I can sit down with planning staff. They are required to have the designs of buildings. This is for every preliminary subdivision. Everyone is approved by the planning board. My clients can ask for boards which show the texture of what's going to be the outside of the building or what the shingles are going to look like. I mean, in some cases it may be overkill, but there is the ability to work hand in hand. And that the working hand in hand doesn't come because the development community always just embraces the citizens. Working hand in hand comes because there's a respect for the citizens, and they have the ability, because they have a right of standing, they've got good regulations, they have the ability to go into court and win. I mean, my track record where I lost, I think it was every time in Howard County, except on Route 100 when we went to the federal government and got them to intervene, I think I won every case in Prince George's. Or we have settled and come to an accommodation with all parties. That's a totally different perspective than here. So I would challenge you to look at the procedural things, but more importantly, you've got to have your fundamental structure in place. You've got to be able to have citizens at the table, and they've got to have the power to be there, not because they have money, but because they have basic rights in a community that everyone has to respect.
Thank you.
Thank you.
Next is Angie Beltram.
That's a tough act to follow, Angie.
And following Ms. Beltram, Dale Schumacher.
Okay, I'm going to go through every page because I have some comments.
These are our last two speakers, incidentally.
Sure. First, I'm going to say that we didn't talk about campaign financing, and I think we have to provide something in legislation that requires recusal of county council members in land use decisions if the petitioner is a contributor of campaign money while campaigning and during their term. I think that's not even considered. The HB 246, I don't know if you're familiar with it, that was the standing possibility of enabling bill to permit the county council in Howard County to create legislation that would provide standing for people in land use issues. And 7 other counties have it, 17 municipalities, 17 counties have it, and maybe 20-some municipalities have it. And it was turned down, and I'm sorry, Mr. Erskine, but he testified against it for the Chamber of Commerce, and it's going to be brought up again. But that's public engagement. I want to go through the committees. Subcommittee, I like what's in the reports, basically. Subcommittee 1, I like. Subcommittee 2. Number 3, instead of call it district meetings means to me council management district, and I think we ought to do area plans because some of them overlap. Town hall's good. An area meetings again.
What page are you?
Oh, no, I'm sorry. Area meetings on number 3. And then we go to the next page, subcommittee 2. I think number 3 again, there should be area meetings when the planning board's dealing with it, because the process is going through. Number 5 on that page 4, it should say adjacent, not adjoining. Adjacent is in the regs. Adjacent means across the street as well as next door. That's what adjacent means by regulations. Now, number 6 on page 4, public comments to the council can be made verbally at open hearing, blah, 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 blah. However, normally you get 3 minutes when the developers have already talked to the council during comprehensive zoning, not during piecemeal rezoning, hopefully. Comprehensive zoning, the developers or attorneys have already sat down with the council in many of these, when these petitions come through, which is the way they learn what the petitioner wants. So they might spend a half hour, and we get 3 minutes to respond. So I have a concern about it, but I don't want everything to last all night. But you realize that's what's happening. Okay, let's keep going. This is subcommittee 3. Number 4, for the second community meeting, if anything has changed, including maybe variances have come up, which was not expressed at the first meeting. I was at a pre-submission meeting a few years ago, and people learned what was going on, and when the petition came through, it was completely different, and I was ready to say that, and this is before we had new provisions, but it was withdrawn. Number 5, PUD. PUD, if ever adopted, becomes the process. This is substance. You all talked about not providing substance. PUD is a process, but it is substance. To recommend that. Okay, page 8, number 3, require UZ to make sure that everything's going on. Now, I have had 2 occasions where I read an ad in the paper, public notice of a variance, special exception, conditional use, or whatever, and signs were not posted, and I called the person who you're supposed to talk to, and she swore the signs were up, and I said, well, either I'm blind or what, because they are not up. And I know she didn't see it, and I know she lied to me. Okay, it's already been stated about ZRAs being illegal. I'll state that again. Okay. This advisory panel, oh, by the way, I'm representing Cook, Citizens for Open Process for Everyone, so give me 2 more minutes. That's fine. I forgot to say that. I forgot that. I have a problem with this. I read it briefly, so I might be mistaken, the bill. And it talks about planning areas and so on in downtown. My concern is it's really going to be focused downtown Columbia. You can say Route 40 was a planning area. This is the planning document. This is Route 40 Hampton Committee. We met over a year. Okay? We have no design manual. We have no project manager anymore because the project manager who was assigned to us, and a letter was written to the Route 40 Committee saying, here is your new project manager. And his name is, he was here for me last night. I tell him this every time, so he knows what I say. And guess what? He was assigned to the charrette in Columbia. And he's been working on that. And that's why we don't have a design manual. And that's why when you all have this committee, some things may never happen. See? And I agree with Diane Butler. Same thing happens. Okay? People are ignored. So I'm going to watch that design advisory panel and see what they really do. Adjacent, also, okay, page 10, just, again, adjacent in number 8. Rules of procedure. I think the planning board does adopt their own rules of procedure, but I think really the council ought to. I think that ought to be considered. They can develop their own, but I think they really ought to be adopted by the council. I'm not sure, but something to think about. And number 13, page 13, number 10. You may not, if you've been to a zoning board hearing, and some people come in and say, I have this petition, we're against this, and so on, and the attorneys will object and so on, and I understand it all. But the zoning board says, we'll take it for what it's worth. That's what they say. Planning board says, you can't put that in. We can't take that. So they're stricter than the zoning board. Okay, so I think that they are not, they just don't treat citizens very well. Now, the zoning board, have an independent zoning board. I absolutely agree with that. We have Ms. Powers, who is the type of person who has the credentials to be a zoning hearing officer. And the petitioner comes in, states they're changing a state case, and if it is not there, you stop the hearing. If it is there, then you come in with a site plan. You show me what you're going to do. Don't show me you want a gas station, and then you have a fast food. You come in and say, okay, there's a possibility of changing state. Let's continue the hearing. Then you come in with a site plan and say, this is what we're going to do. That is a process that people understand, and strict change of state. Okay, the last thing I want to say is that we always provide a hearing impaired interpreter, and I have been in one occasion, and possibly a second one that almost came up, where I went to a pre-submission meeting and the petitioner did not speak English and the daughter was interpreting. That case never came to the board, hearing examiner. However, there was another one I went to, and there was a signed variance, and the person spoke Greek. And the lawyer spoke Greek, and I had to interview the lawyer. I had to cross-examine the attorney, which is illegal. I mean, that's not due process for me, because I don't know what he was asking her and what she was telling him, you know. So I called Robin and I said, I want an interpreter. And she said, what? I said, I want an interpreter who speaks, you know, this was different language then. And she said, we don't do that. And I said, I think I read somewhere that you do. And then she said, no, we don't. And I said, let me think about it. So then I called her back. I said, I know. I read that you could ask for a hearing impaired interpreter. That's what I read, because it says it on every document. But we have a diverse community. And I think that if that comes up, and if I'm in that position again, I'm going to object and say I don't want the hearing to go forward until I can really cross-examine. So it's just something to think about. It probably won't happen that often, but we probably have more diversity than we have hearing impaired here.
So you'd ask a question of the lawyer, and he would turn to his client?
Yes.
And then you don't know what the client said,
No.
but he would tell you?
Yeah. I mean, that's the
And he's
only way
on
it
his
could be.
scout's honor.
And after I left, I thought, why didn't I object and say, I can't do this? So that was it.
I would pretend like I couldn't speak English.
But I told my Italian friends, I'm going to bring them in.
That's good.
My friends from Sonsville, I said, next time I go to hearing, I want you to come in and say, I'm against this in Italian. See what
I have a question. Hi, Angie.
Hi.
Go back to your first point about the campaign and things. Could you reiterate that for me? Just
Yes, I think there are some counties that do this, and I can get you the citation, you know, the information on that. If during the campaign there is a donation to your campaign, and then you are elected, and you have a zoning decision, you should not be able to vote if that's the petitioner, or associate, the member, the attorney, the spouse, if you can find it. It's simple when it happens. Or during the campaign, because sometimes you have fundraisers after you're elected too, so that's before and during. But we have, I mean, there's something coming up now that I'm going to testify about that I know the reasons are because of some campaign donations. I mean, it's at least it seems that way. Can't prove it.
Yes, is that for any amount of money in terms of the
Well, I might
donation?
have to say $1,000, $2,000, I don't know yet. I'm looking at some other county that has this in their regulations.
So it would be an
So I'll let you
appreciable
know.
amount of money?
Yeah. I mean, you know, I've been in a situation where a constituent may give me $50 and they're against something. So do you vote their way because they gave you $50 or what, you know? So, I mean, I will look at what that limitation is, or minimum is.
Sometimes don't they have a requirement of disclosure
Oh, yeah,
also?
they do.
I mean,
They do, yes, they do. I think it's over $500.
makes sense.
Something like that, $500.
I remember during comprehensive, that was a requirement, you had to state whether you contributed $500 a council person.
Well, you know, that's compromise, but I'm looking at it because campaigns cost a lot more money than they did, say, 20 years ago. I know they did. There's a lot more money out there.
Thank you very much. Next is Dale Schumacher, and following Mr. Schumacher, I have Brenda Stewart. Yeah, just that.
We had an add-on.
Good evening, thank you. Appreciate the opportunity to be here. Dale Schumacher, 6581 Beaumont Woods Drive in
Elk Ridge, was involved in planning, Elk Ridge Master Plan Citizens Review Committee in the early 80s, was on the planning board in the 1990s. In 2003, our family negotiated a permissive covenant with the Belmont Retreat Center. Only access to Belmont is over our historic Rockburn property. And currently, what I view as a failure in the system, we're in the courts with Howard County Community College and the foundation. And I think it's a difficult situation where you have hard-working, responsible citizens and you end up in the courts because the process doesn't seem to work. I may comment on that later. But this evening, let me talk a little bit about some strategic issues. And what I've heard so far just reinforces that. And that is, we have a real problem between the legal interface, the bureaucratic processes, data and information, and the resulting transparency or non-transparency that we have in Howard County. We just heard, I don't know if he's still here, a gentleman that said in Maryland we're 45th in the nation. We have a 4-hour and 37-minute wait in emergency rooms. Many of you can DPZ tell us with that degree of certainty about the status of particular zoning cases. I can go home, you can go home, go on your web and look at the status of 4,000 hospitals in the United States in terms of the clinical quality of care that they provide and the level of patient satisfaction. 4,000 hospitals across the country. We can't quantify our planning and zoning process. What I've heard tonight are just almost pathetic workarounds for a process that doesn't work. I was on the planning board for 4 years, and I no longer recognize and feel reasonably confident in the planning process. So what do we have to do? Well, we have to approach this like a business. We've got to develop standardized data dictionaries, data formats. We have to specify the structure. Go to the Harvard Business Review. There's an article by Hammer in April 2007 that talks about standardizing processes. It's slack-jawed. This county, with all the affluence and smarts that we have, cannot develop a routine standardized process. So what are some of the specific recommendations that we might have? As I alluded to, data standards, regular processes. People have said that again and again tonight as I've listened. Recommendation 2, there's been considerable discussion about attorneys, and I love them. Some of my best friends are attorneys. But the future is not going to be built on one-off types of cases. The future is going to be built to the extent that we can standardize. We heard discussions about Prince George's, Montgomery County, how about what goes on in California, Wisconsin, and so on. There has to be standardized processes out there, data information about cases, ones that are successful, ones that are not. Let's get data analysts that citizens, attorneys, developers have access to. When there's more transparency, the system will work better. And I think we've heard that one way or another. The thing that prevents us here is that we have these one-off sort of messy systems. Third thing, and my last point, public-private partnerships need to be more transparent. In our work and in our efforts to help the community college and the Howard County Community Educational Foundation, we've run often into a brick wall in terms of transparency. 3 times we've had to go to the circuit court with motions to compel to get information about our zoning planning case. And that's not the best way to have things go. So I think that's a good example of how we need to have a more transparent system in the economy. Once you have transparency, things work much better. Go look at the website, and I'll send you my material so that with the websites, and you can look at all the hospitals and their performance.
Thank you very much.
Go ahead.
Thank you very much. I had a question. I had the impression that you were on the planning board in the 1990s and found things worked reasonably well, and you feel somehow it's declined. Can you identify what that would be?
Right. Right. There were times, and let me say, there were times when we felt that we were fairly aggressive. There were some issues in Columbia, to give you an example, where we felt that the quality of development was not evolving the way it could be, or was maintaining the standards. And let me give you an anecdote, and from one anecdote, I'm shooting myself in the foot from what I said before, but one anecdote doesn't a process make. Two of us on the board, Ted, architect, come back to me. He and I raised questions about a development, and we were told by someone in the county staff that if we pushed that quality issue, that we would be seen as arbitrary and capricious, and if the developer took us to court, the county might not be able to defend us. Now, how is that for support, enthusiasm, structure, process, and so on? Second thing, we asked many times, I did, because I'm a data guy, I make my living off data, for information, detailed information about traffic planning. We couldn't get it. We could not get access to the detailed data regarding traffic planning. And I know how to handle data, let me assure you. And depending upon how you slice the data, I'm sure some of you are involved in it, which distribution you use, is the binomial distribution, the normal distribution, blah, blah, blah. Your results, sometimes if they're on the edge, can go one way or another. So we pushed for that, we didn't get it, and I would say that was a bit of a shortcoming. In the past, I was very enthusiastic about planning, and I just don't know, with things being as complex and the process being as disheveled, whether 5 hardworking citizens can stay up to pace and handle all the things that they have to do. And that's why we have to get more standardized, better information, because with a data analyst and a more methodical, systematic process, 5 individuals that can access large databases and so on could make those decisions and be much more efficient.
If I can just finish. Would it be possible for you to write down your recommendations with some specificity? It's a little difficult for me to get a handle on exactly how you would phrase it. And if you could furnish that to what, to Theo, or put it on the website? The website, there's a link. I think your experience on the prior planning board is invaluable, and we need that kind of input.
Very honey. But glad to do that.
So Dale, am I understanding you want the original data out there?
Oh, yes.
Before anybody does any interpretations of it?
Well, it should be on the web in some. Years ago, we didn't have Excel. We didn't have access. We didn't have PDF files. Let's put them out there, and then that becomes an opportunity for citizens, for developers, for attorneys, for everyone to compete at a higher level. And it's no longer rocket science for the county to say that all traffic consultants will produce data in this format. That's what I'm saying. If you can tell 4,000 hospitals to produce data in this format, so you can go home on the web and look at it, we can darn well tell a bunch of consultants, I tend to be a consultant, how you're going to produce the data. It moves the process, elevates the process. It makes it much more transparent. The downside of that is it may take some attorneys who are accustomed to sort of case-by-case work and reduce their income because they get paid for doing the workarounds. For those, there's an upside. For those attorneys...
Tell me about it. I want to hear this.
For those attorneys that are comfortable with trends, information, and putting their case in the perspective of I mean, you say, I have a case that we want to have the frontage of the buildings closer to the road. And I can prove that in these 32 cases, the volume of traffic, it was condition D and E at this point in time, whatever, but there were no traffic accidents and no fatalities because I ran through the database and showed that positioning of the building with this type of intersection makes no difference. so that if you can use that information, I think we come out better as a county in longer terms. So you see the difference I'm trying to make. The one-off stuff is going to go away as you become more transparent, you have the data. The process is going to get more sophisticated, and the attorneys and the planners that are really good will survive and do better. Thanks very much. Keep up the good work. We got to get this stuff out.
Next is Brenda Stewart, and then Sherman Howell, who's also been added to the end of the list.
My name is Brenda Stewart. I've lived 37 years in the western part of Howard County on a farm. I've just recently become the president of the Concerned Citizens of Western Howard County, a nonprofit incorporated organization. And this came about because of certain zoning mishaps or certain zoning issues that were not picked up on during general plan. We are now faced with, in a rural conservation area, of someone who we have been told may put a used car lot agency when it is surrounded by rural conservation, ag preservation, scenic roads, and it would go through because there were no submissions that had to be done because the zoning of B2, which was put there 50 years ago, was never picked up on in any of these general plans and looked at as not compatible with what was going on around it. Now, 50 years ago, in this particular 4 acres of zoning, and there are other hotbeds like this around, I really truly suggest looking at this B2 zoning out here in western Howard County. There was never anyone who was interested in it because it was very low key. It was mom and pop or groups of people that were. They had a market there. They had this piece of property had ag tractors and so forth that were repaired, and it was very low key. But B2, as most of you know, is the same kind of zoning you have out on Route 40. And that's what we're faced with right now. So that is the reason why the Concerned Citizens of Western Howard County got together. The second issue that we discovered is that when you come to ask about safety issues out here on scenic roads, the DPW and the DPZ do not work together on this. The DPZ had one engineer that looked at the information, and they allowed the person who wanted to buy this land to run the traffic study. And the traffic study that they ran was how many cars per hour in this particular area where they want to have their used car lot. Well, obviously out there aren't many cars per hour. They also study the traffic reports. Well, if you don't have many cars per hour, your traffic and your accidents and so forth will be low. They also checked to see if they had adequate exiting and entering onto this car lot by WB50s, which are large car carriers. Those were the 3 studies that were paid for by the person who wanted to buy the land. Nothing was done to check the scenic road that was going to be used, which is Union Chapel Road. Nobody checked it. We, as citizens out there, said this is ridiculous. We're going to have something 50 feet or more that's going to make hairpin turns on 90-degree angles. There are no shoulders on the road. The road is narrow. The third issue was the general plan. We said to ourselves, well, wait a minute, the general plan specifies that this is ag preservation area, this is rural and scenic roads, we're going to preserve all this. So we said to ourselves, well, why wasn't somebody reading this and using this as sort of the Bible, the structure of why this would not be appropriate out here? That's a question I'd like answered is the general plan policy? Is it guidelines? Or is it something you want to strictly adhere to? Because we certainly could have used help from the general plan or someone looking at it for us, and nobody did. So what we had to do was we had to bring in our own traffic engineer specialist. We hired a WB-50 carrier to go up the road. We videoed it. We also videoed how it had to make these turns and go way over the center line. There were no sight distances that were ever measured by anybody except by us. And we also had to do a second study which showed that the exiting of a WB-50 into this car lot agency or out of it, they also were dangerous. Now, they want to put a roundabout out there on Union Chapel Road and Daisy Road where they intersect. Well, this WB-50 wouldn't get around that unless it cut into the other lanes as well. It won't work. But we had to hire somebody to bring this to the attention of the WPZ and the WPW. And they looked at these videos and they were amazed. We haven't heard back. We submitted the first one a week ago. It would have been nice to get an email response and say what they're doing about it, what they're looking at. We never got that, and I'd certainly like to see that covered. So this is a situation where I think, I don't think there's anything on there about examining these B2 areas out here in western Howard County. I truly believe that this should be done and diligently. Secondly, I don't have, none of us on this, and the concerned citizens have, and incidentally, we had a town meeting that had over 200 people just on this issue. And they came and they all emailed and signed up that they did not want that out there. But the second issue is, why isn't the DPW looking at this? Why didn't they see this? Why wasn't there anybody that came out there to actually see Union Chapel Road, a scenic road, being utilized now for car carriers? And we've met with our councilman out there, and I cannot accept the fact, well, I wasn't in office at that time. I can't accept that. You're in office now, do something about it. And I'll conclude with that. I have a couple of questions. Looking through this, you have a zoning board council. How can the public use the zoning board council? Or do we have to pay for that as well? To get a council? How does that work?
There is a council that serves the zoning board, and you can request that they attend pre-submission community meetings. They can also advise you on the processes and the procedures of zoning matters within the county. They can't give you legal advice, however. Under the current regulations, they don't act as a people's council, so to speak, or they don't represent private citizens. In fact, they're prohibited by law from practicing in Howard County. But as a resource, Eileen Powers is her name. She is available as a resource to direct you, to point you in the right direction, and explain the processes and the procedures.
Okay. The other question I have is the adequate facilities. Does that cover us as far as roads, looking into that?
It will at the site development plan stage, yes.
Okay. I doubt that has been done.
I'm not familiar with the project, so I don't know if they're planning structural improvements, but it's a change of use of the site, and it's commercial, so I would think they would have to go through the...
Well, they didn't change the, B2 was already there.
No, but what was the use on the property, on the B2 prior?
It could be, well, when it started out, that's a good question. When it started out as B2, there have been a lot of additions since then, because right now, along with its allowing a car lot, it can allow a bar, a girly show, a movie theater, I mean, other things out there that are totally not the right use for in a rural conservation area. I mean, you can have a adult bookstore. in B2 out there. So that, I think that the general plan...
I think my partner may have represented your community,
Tom Meacham.
Mr. Meacham, right?
Yes, he did.
I don't want to answer his questions, but you might call him and ask him.
No, we have,
Yeah,
but this traffic...
Because I might give you different advice, I don't know.
This traffic study was on our nickel.
If I may, would it be possible for Ombudsman Kimberly Flowers to get the phone number for the zoning council, Eileen Powers, and give it to the witness?
You got a comment?
I see a...
I'll come up here on the zoning council issue, okay? As a member of the county council, the zoning council actually works for the county council, and as a result works for you. And any community group that wants advice on anything has the right to request her time. Simply do it by calling Robin Regner, who is the administrator for the zoning board, and request Eileen Powers' time. You'll have to, of course, work out a time that works for your community as well as for her, but she is available to come out. Okay? And so just call into the county council office, 410-313-2001. Okay?
And just so you know, she's not a staff attorney. She actually works for a private law firm in Anne Arundel County. So I think, like, the time that she spends, she bills the county council for it.
Yes, but we have...
There's a budget for it.
Yes, we have a budget for it, and there's plenty in the budget to have her out working in the community. Okay?
And she can find, the information is on the county council website, so she doesn't have a little click on there.
I think we're to our last speaker. Yes, Sherman Howell is the last speaker I signed up.
Not least, however.
Thank you.
Yeah.
Mr. Chairman, my name is Sherman Howell, and I normally testify on behalf of the African American Coalition of Howard County, but I was just recently made aware of this particular meeting, so I don't have things written down, but I will try to get you some information. I've been involved in land use issues since 1972, starting with the first county executive, Omar Jones. And at that particular point in time, of course, the issue was exclusionary zoning. There was a major complaint in the county regarding that, and the Baltimore Sun carried my opinion in terms of that. And I've served on several land use planning committees in the county, and they all seem to work fine. But I agree that we need to have addressed what this committee has been charged with addressing. Specifically, I would like to see an explanation of zoning in your report. Explanation of zoning. I also would like to see answered or explain why we rezone. Why do we rezone? What is a ZRA? You know, here recently, we've heard the the national presidential candidate speak of a post-racial society. Senator Wammer gave the great speech there. Senator Clinton over the years have worked with black kids. And even Senator McCain is saying he's going to go into the inner city as well as before black groups to address this issue. In fact, Mr. Dunbar, who's here tonight, encouraged me to invite Mr. Obama out to my house just before he announced. Of course, I contacted Mr. Obama. He was too far gone then. He just couldn't come out. But at any rate, to reach a post-racial society, we're going to have to deal with affordable housing. We're going to have to deal with a strong economy, as we learned last night from GGP. And we're going to have to explain to people in my church who need housing why we can't come up with an ecological system in Western Howard County to house police, teachers, and firemen. So, in conclusion, I hope that we do not codify. I served on many task forces. I'm assuming that you're going to come up with some language that could go into the law as well as to policy. And my last request is that we be very careful in this codification process, if I'm pronouncing it correctly, and this policy process, not to instill in that process this quote-unquote againstness. We've had this againstness,
in this county for I don't know how many years. I ask you all that when you do your final report and you come up with your final recommendation, think about, we don't want that against us in the county. And that's why we have Columbia. And that's why, by the way, that's why I wanted to invite Obama out to Columbia, because I thought Columbia was headed in the direction that he, in my perception, was going to go. Thank you very much.
Thank you.
At this time, would anyone else like to speak?
Who hasn't already?
Who hasn't already? Okay. What other business do we need to attend to tonight?
Anything else on the agenda?
Well, just remind folks of the next meeting.
Yes. We go back over that. Here. We have a meeting scheduled for April 15th where we're going to be voting on the individual items in the from the proposal list. 6 o'clock, yes. And we also have a meeting for April 23rd, correct? 23rd. This sheet says 22nd, but it's actually the 23rd.
We just, there was some discussion. There's a public hearing for the council.
Also 6 p.m. And again on the 30th, and the final report will be delivered to the county council on May 7th.
I have an informational question. We have heard some new ideas tonight, and part of the reason for the hearing was to get ideas in addition to those that we've generated so far. Are we going to be voting on new ideas as well, and can we add to our list?
Absolutely. I would think absolutely.
Please. Good idea is a good idea, no matter where it comes from.
Especially if we can circulate them ahead of time.
Yeah.
Yeah, I just want to comment too that last night I saw Bridget at another event, and I commented that I was going to come tonight and didn't expect to hear anything that I hadn't already heard before, but I want to compliment the people who came out and spoke, because every single person who said something perked my ears and said, wow, that's a good idea. So thank you very much for participating publicly.
Thank you, everyone. And with that, the meeting is adjourned.